Good afternoon. My name is Justin Streckel, and I am an organizer and the founder of Better Organizing to Win Legalization. And I'm very excited to welcome all of you here today for an incredibly important conversation that is hosted by a group of leaders throughout the advocacy and industry communities when it comes to marijuana policy reform entitled United for Marijuana Decriminalization. These leaders have been working for years and years to make sure that we can push for thoughtful, comprehensive reform. And upon the recent news of the Department of Health and Human Services leaking a letter that they had transmitted to the DEA, we came together to formulate a plan for the Biden administration to be able to proactively move forward and make sure that marijuana policy is thoughtfully being addressed in the 21st century. We have a wonderful lineup of speakers tonight, ranging from the advocacy community, industry community, former regulators, all of whom bring very, very different, very unique, and at their highest level expertise to this conversation. And we all look forward to working with you and standing united for marijuana decriminalization. With that, I'm going to turn it over to my colleague, Chelsea.
Justin, you're out of order. I hate to tell you, but I'm actually next.
Wait, I lied. With that, I will turn it over to my esteemed colleague, Michelle.
Thank you, Justin. Chelsea, don't worry. Everyone's going to get to hear from you in a second. Hello, everyone. My name is Michelle Rutter-Freeberg, and I'm the Director of Government Relations at the National Cannabis Industry Association, or NCIA. We are the oldest and largest trade association representing the legal cannabis industry. And if you guys haven't heard about us or want to learn more, I encourage you to visit our website at www.thecannabisindustry.org. And I'm pleased to be here today to talk to you all a little bit about the difference between descheduling and rescheduling. So just to give a little bit of context, the Controlled Substances Act, or the CSA, as you'll probably hear it referred to a lot today, was signed into law by President Nixon in 1970. The CSA is comprised of 5 different schedules, with 1 being the most restrictive and 5 being the least. Classification is based on potential for abuse, which is a largely undefined term, and currently accepted medical use. Exactly 1 year ago tomorrow, so this is why we decided to hold this today, President Biden announced that his administration would initiate the administrative process to review expeditiously how marijuana is scheduled under federal law. The first step in that process was for the FDA, under the Department of Health and Human Services, to conduct a medical and scientific review to determine if and where marijuana should be placed or scheduled under the CSA. As Justin alluded to, in August 2023, news broke that HHS had recommended that marijuana be placed in Schedule 3, though that recommendation is still not available to the public. Next, the DEA will review those recommendations and announce its initial determination in the form of a proposal before any formal changes are actually enacted. But there are major differences between Schedule 1 and Schedule 3. Schedule 1 is the most restrictive placement for substances under the CSA. That is where cannabis is currently placed. The federal government considers Schedule 1 substances to have no accepted medical use and a high potential for abuse. On the other hand, Schedule 3 substances are considered to have accepted medical use, but only moderate to low potential for abuse. So as you can see, there are very clear differences, not only within the various schedules, but again, there's also a huge difference between rescheduling and descheduling. So descheduling is the removal of marijuana from the CSA, while rescheduling, as I alluded to, moves marijuana within one schedule to another. Descheduling decriminalizes most marijuana conduct at the federal level, including personal use and possession. On the other hand, rescheduling maintains nearly all existing federal criminal penalties for marijuana, including penalties for personal use and possession. I'd be remiss, as someone who represents the cannabis industry, businesses, primarily small businesses, not to mention that moving cannabis from Schedule 1 to Schedule 3 would eliminate what's known as 280E, which prevents companies taking standard business deductions associated with the illicit sale of Schedule 1 or Schedule 2 drugs. But that being said, rescheduling would fail to decriminalize cannabis, would not lawfully permit the existence of the medical and adult use programs and businesses that now operate in 38 states, or rectify decades of injustice associated with more than 25 million arrests and related collateral consequences since the creation of the CSA. So with that, now I'm going to hand it off to our next speaker, Chelsea. Take it away.
Thank you so much, Michelle. My name is Chelsea Higgs-Wise. I'm the co-founder and executive director of Marijuana Justice. And we are really proud to be part of the leadership team here in Virginia that made Virginia the first state in the US South to repeal prohibition of simple possession and legalize home grow. Now we're working with federal advocates to empower grassroots organizers working on the ground across the South and across the country to push for justice that's been promised to us for so long. We're here to propose a plan to the administration because the recommendations of rescheduling alone will not fulfill Biden's promise to decriminalize nor to reform the racist war on drugs. Rescheduling alone will not release anyone currently incarcerated for marijuana convictions, nor expunge any marijuana-related records. Rescheduling will also not address the immigration-related consequences, which are the leading cause of deportation in the United States. Rescheduling will also not restore eligibility for public benefits such as housing and food assistance. Rescheduling alone will also not federally legalize the existing medical nor the adult use regulatory programs, which currently exist in 38 states and employ over 400,000 workers. These operations would remain federally illegal under rescheduling alone. If marijuana is only rescheduled with no further guidance, virtually all medical and non-medical use of marijuana currently legal under state law will remain federally illegal and a criminal offense. Although existing cannabis companies would no longer be penalized from a federal tax perspective, which is great, all cannabis products, including plant products, edibles, topicals, will remain illegal unless individually approved by the FDA. So whether you've been negatively impacted by prohibition, you're a worker within the cannabis community, maybe you're a business owner or a consumer, none of us will feel the benefits of rescheduling alone. Further guidance must come from the Biden administration, just as promised. And I'm going to pass it on to Kapp Packer.
Thank you, Chelsea. My name is Kapp Packer. I'm the Director of Drug Markets and Legal Regulation at the Drug Policy Alliance. It's true, rescheduling would be completely insufficient. But the good news is that it's not too late for President Biden to keep his promises and to take steps to truly right the wrongs of marijuana criminalization. Communities all across America are dependent on the president to follow through with his commitments, especially the commitments that he made explicitly to Black and Brown communities. After all, marijuana criminalization has ruined lives and disproportionately harmed Black and Brown people. But don't take my word for it. These are the words and acknowledgements of our president. He expressly acknowledged during his statement last year these disparities, and he's continued to repeat this acknowledgement over and over. While we applaud this acknowledgement and his commitments to take steps to end the country's failed war on marijuana and right the wrongs of criminalizations, acknowledgements and commitments simply aren't enough. And we're concerned that rescheduling marijuana without additional reforms would leave the underlying issue of criminalization and its harms, which is purportedly the motivation for President Biden's executive action, completely unaddressed. During the 2020 presidential election, President Biden acknowledged that the harmful drug policies that he supported back in the 1980s and 1990s that disproportionately harm Black communities were a mistake. In his plan for Black Americans, which he called the Lift Every Voice plan, he promised to decriminalize the use of cannabis and automatically expunge all prior use convictions. Rescheduling marijuana to Schedule III again would leave those issues completely unaddressed. Since in office, President Biden has repeatedly called marijuana reform an equity issue and has said that the federal government should pursue a comprehensive approach to advance equity for all. But marijuana reform is missing from the administration's equity action plans, which required agencies to assess how their programs and policies perpetuate systemic barriers to opportunity, and required agencies to develop evidence-based solutions to advance equity. This represents a missed opportunity to address the disparate impact of federal marijuana policies on underserved communities. It's kind of crazy that the Biden administration has this entire framework for the federal government to assess how federal policies create barriers for underserved communities. And yet marijuana policy, which we can all acknowledge has created barriers for underserved communities, is missing from this administration's comprehensive approach. So as the president continues to talk about how harmful marijuana criminalization is and how it disproportionately impacts Black and Brown communities, we are demanding that the administration use the full extent of their authority to address these issues directly, especially since the current process to review how marijuana is considered at the federal level will not consider these issues at all. To keep his promises, President Biden must do more than call criminalization a failure. He must take action to actually end that failure. And the good news is that it's not too late. By acknowledging the limitations of rescheduling and taking proactive steps to advance equity, President Biden can ensure that his administration delivers on the promises and aids communities most harmed by the failed criminalization of cannabis. Now passing things to my colleague, Khurshid.
Thanks, Kat. My name is Khurshid Khoja. I am the Chair Emeritus of the Board of the National Cannabis Industry Association. And just to bolster what my colleagues have said, contrary to decades of reefer madness propagated by our federal government, the FDA now admits that marijuana does have accepted medical use. However, reports of the death of cannabis prohibition are exaggerated. While the HHS recommendation to the DEA to reschedule marijuana could finally bring relief from punitive federal taxation of struggling state licensed cannabis businesses, it also underscores the urgent need to both continue pressing forward on full decriminalization and demand that marijuana be exempted from existing categories of FDA-regulated products in order to preserve state medical and adult use cannabis markets. Many of the statutory criminal penalties under the CSA are either specific to marijuana or apply to all controlled substances regardless of their schedule designation, and would still apply even if marijuana were moved to Schedule 3 or lower. This is also true of certain sentencing enhancements. So, for example, 21 U.S.C. 841 prohibits manufacturing, distributing, dispensing any controlled substance and possession of a controlled substance with intent to manufacture, distribute, or dispense. Now, generally, Section 841 prescribes harsher penalties for substances in Schedule 1 and 2 than those in lower schedules. However, Section 841 also contains substance-specific penalties for manufacturing, distributing, dispensing, and/or possessing certain defined amounts of marijuana, while applying schedule-specific penalties for marijuana in amounts weighing between 50 and 100 kilograms or between 50 and 99 plants. As such, rescheduling alone would preserve substance-specific criminal penalties for cannabis commerce under Section 841 of the CSA, and Congress would need to deschedule cannabis altogether to eliminate these penalties. Without this change, cannabis businesses and their principals would continue to face life imprisonment under 21 U.S.C. 848 for operating an ongoing criminal enterprise, regardless of a move to Schedule 3, because that sentencing enhancement applies to substance-specific violations under Section 841, including violations involving more than 100 plants. It's also true that 21 U.S.C. 844 punishes simple possession of any controlled substance without a prescription, including those substances in Schedules 3 to 5. So rescheduling alone would not reduce or eliminate those criminal penalties. The same is true of the sentencing enhancement for possession of firearms under 18 U.S.C. 924, which applies to all drug trafficking felonies, including those involving controlled substances in Schedule 3 or lower. And no, Schedule 1 is not better than Schedule 3, but rescheduling alone is not enough. To be absolutely clear, the immediate benefits of rescheduling to Schedule 3 would be an improvement over the status quo. That said, there is no contradiction between welcoming these benefits delivered by Schedule 3 and being cognizant of the other downstream implications of that potential move or being prepared to address them, including acknowledging that the potential imposition of criminal penalties under both the Food, Drug, and Cosmetics Act and the CSA is not an improvement over criminal penalties imposed under the CSA alone, since both sets of penalties would apply to cannabis post-rescheduling. While the FDA does not currently exercise its authority to enforce the Food, Drug, and Cosmetic Act against state legal marijuana, there is ample reason to expect that the FDA can and will exercise its existing authority over drugs food additives, and dietary supplements, and in fact has already done so with respect to hemp products in the event of any move to Schedule 3 or lower, including descheduling. This would be consistent with the observations of other legal scholars, namely that the FDA has historically punted to the DEA on enforcement of federal laws prohibiting commerce in Schedule I controlled substances, including marijuana. It's also reasonable to draw conclusions by comparing the history of FDA efforts to enforce the FDCA against hemp products, both before and after the Farm Bill effectively descheduled hemp and hemp cannabinoids. As such, carving out state-sanctioned marijuana products from the FDA's legal definitions of drugs, food additives, and dietary supplements is a necessary step that must be taken quickly in order to preserve existing state markets, small businesses, jobs, and consumer access. We have to demand a new approach by the Biden administration, including new regulations by the FDA, and ultimately a new statutory pathway for marijuana. With that, I'll pass the mic on to my other colleagues who will cover our three asks. Please feel free to pose your questions in the chat. And if you're interested in hearing more about the FDCA issues, please check out my paper on the Parabola Center website called Cannabis Cannibalism.
Thank you, Christine. Hi, everybody. My name is Cheel Tidle. I'm with Parabola Center. Thank you to everyone who is attending, everyone who takes the time to watch. I hope to collaborate with many of you on federal reform. So I'll be presenting the first of our top three asks for the Biden administration. These requests make up a three-part roadmap toward marijuana decriminalization and justice. While the most straightforward solution would be to remove marijuana from the Controlled Substances Act entirely, these are incremental steps that we can take now in the right direction and toward fulfilling the president's promise. As my colleagues have noted about rescheduling, virtually all medical and non-medical marijuana use that's currently legal under state law would remain a criminal offense under rescheduling. And at the same time, rescheduling would open a new pathway to a legal national market that would basically only be accessible to pharmaceutical companies. And so when I say incremental steps in the right direction, I mean away from criminalization, away from monopolization and big pharma, and towards a legal public health framework that would protect all of us, especially consumers, workers, and small businesses. So I'll be presenting the first step, which is focused on stopping the harm, followed by Marissa, who will be presenting the second step, which is focused on repairing the harm. And finally, Natasha will present the last practical step, which would put us on the right track going forward. So our first ask to the Biden administration is to issue guidance from the Department of Justice that pertains to individuals in addition to licensed businesses, including deprioritizing prosecutions for marijuana-based conduct, seeking reduced sentences, and ending marijuana-related deportations. While guidance is not binding, it's not law, it's not a replacement for law, new guidance on these issues would be a valuable incremental step. I'll conclude with a quote from our respected Attorney General, Merrick Garland, who said, "The marijuana example is a perfect example. We can focus our attention on other crimes and not allocate our resources to something like marijuana possession. We can look at our charging policies and stop charging the highest possible offense for the highest possible sentence." So we can start with that sentiment. And separately, to be clear, there should be zero federal arrests for marijuana possession, not a low number, but zero. And marijuana use should no longer be used as evidence of poor moral character, which has consequences, a violation of parole, or grounds for any federal employees to lose their jobs. Again, these are all things that can be addressed right now, regardless of rescheduling. And so to summarize our first ask, it's crucial that in addition to protecting licensed businesses, that DOJ guidance is issued to put President Biden and AG Garland's statements into practice by shutting down nonsensical marijuana prosecutions. For our second ask, I will turn it over to Marissa.
Thank you, Shailene, and thanks everybody for joining today's conversation. My name is Marissa Perez Medina, and I'm the Director of Federal Affairs for the Drug Policy Alliance. And today I'm going to be talking about our second ask. So again, the restoring individuals who have been criminalized by marijuana. So our second ask is that President Biden expand pardons and commutations beyond simple marijuana possession, including both civilian and military offenses, and that he address collateral consequences by restoring benefits for those with previous convictions. We also believe that he must call on states to do the same. While we applaud President Biden's pardon announcement last year, we have to remember that it was restricted to federal marijuana possession cases and also cases in DC, affecting approximately 6,000 people. This will certainly help and improve the lives of those thousands of people with simple federal marijuana possession charges, as well as DC residents with these charges, but more needs to be done to ensure that all people harmed by marijuana prohibition find relief. A person is arrested for marijuana activity approximately every 90 seconds in this country, and about 1 in 3 drug arrests today are for marijuana. When we're talking about criminal justice relief, we are talking about restoration for millions of people who have been impacted by marijuana criminalization for decades. At the federal level, most marijuana cases are complex and they actually go far beyond simple possession. So to truly make a dent in the criminal justice system, President Biden must pardon and commute sentences beyond simple marijuana possession. Further, we know that most marijuana prosecutions occur at the state level. So President Biden must encourage states to also provide relief for marijuana convictions. A pardon is important because a pardon can remove some of the legal challenges and stigmas that come with federal convictions. A pardon can remove the active penalties associated with the federal conviction that can help people access things like employment, licensing, housing, and federal benefits. But we can't rely on pardons alone to give people their lives back, which is why we also implore President Biden to proactively and explicitly restore federal benefits for people with past convictions. This is important because past convictions still lock people out of opportunities that can positively improve their lives and those of their loved ones. For instance, 28 states have some sort of ban prohibiting people with felony drug convictions from receiving food stamp benefits, meaning that people cannot feed their families. Housing subsidy programs are often inaccessible to people with records, preventing people from finding stable housing. And many professional licenses are denied to people with conviction records, impacting the person's ability to make a good living. The good news is that President Biden can change people's lives today by helping to lift the stigma and real-life collateral consequences associated with marijuana convictions. We invite you to join us in our call to action. Thank you, and with that, I'll kick it over to my colleague, Natasha.
Thank you, Marissa, and thank you to all of my colleagues that have spoken before me. We've heard a lot of tremendous information so far today. My name is Natasha Andrews, and I am the founder and director of the National Association of Black Cannabis Lawyers. We are a group of attorneys, advocates, and law students fighting for a legalization framework that is built on the premise that any national legalization should be equitable, inclusive, and reparative in nature. We've heard a lot of reasons why, and we've heard about the journey as it has transpired thus far. I would like to talk to you about our third ask, which deals with what is the next step, what would come afterwards. We've been discussing decriminalization, which is an excellent first step in the journey of what we're calling for today, but it is just a first step. We would like to ask the Biden administration and President Biden specifically to not only honor his promise, but to look forward and put us in a position where legalization can become a reality. As much as decriminalization is a now fix that will remedy a lot of the ills that have previously been discussed, legalization is what will allow us to move forward with a fully comprehensive and robust cannabis industry. We've already discussed the benefits of that industry, and I think that current and the most recent changes that we have seen on a federal level indicate that that is what is to come next. As we ask for this particular remedy of legalization, we call upon the president to take the types of incremental actions that have previously been discussed, but to take it further. That next step, that further step, is to call on Congress to actually legalize. Although the president, in his own right, may not be able to change a switch from off to on, thus creating legalization by the sweep of a pen, he is in a position, much the same as he did with the pardons, to call on Congress to do what it should do to prevent any further deterioration and to make whole some of the communities that have been devastated and ravaged by the failed war on drugs. The incremental steps that we've seen, and all of those which we have discussed today, should ultimately lead us to legalization. We ask and encourage our president to make legislative changes in the form of comprehensive change that will allow Congress to act accordingly and to provide that legalization that we seek. Only regulations can be done at this point, but our president is incapable of asking for regulation if he does not first support legalization. We call on the administration now to support legalization and the efforts towards legalization. As organizations and as a collective, we are here to support both the decriminalization and the hope that legalization will become a reality. As commander-in-chief of our nation, and while the world watches to see what it is that we will do with cannabis and with the legalization of cannabis, it is imperative that we set a tone and that we set the mark for what should happen, what can happen, what ultimately will happen. We are in support of the president fulfilling not only his promise, but putting us in the best position possible to achieve that goal well into the future. I thank you all for all that you have shared with us, and I'd like to turn things over to my colleague, Kico.
Aloha, everybody, and good afternoon. Thank you so much for being here. My name is Kico Castile. I am the president of the board for the Minority Cannabis Business Association. And as my colleagues talked about today, President Biden has really taken some well-publicized and well-intentioned steps to mitigate the devastating effects of cannabis prohibition, including last year's pardon announcement. But it really is time for our industry and our advocacy movement to unite around the need to ensure that no person is serving time for a plant, and really encourage the president to use the full power of his presidency to end the devastating effects of prohibition on communities of color until Congress finally acts to fully deschedule. And if anybody's been paying attention to the headlines recently, it might be a while before Congress does that. So we want to make sure that President Biden is using the full force of his office right now in this moment that he has to make sure that we can get all that we can from the administration. Obviously, given the historical context of both President Biden and Vice President Harris's opposition to ending cannabis prohibition throughout their careers, the steps they have taken shouldn't be understated. But our fear is also the opposite, that we overstate the impact of federal pardons or potential of rescheduling and take our eye off the prize. That's why our work, and ultimately the president's promise to decriminalize, won't be over until nobody is serving time for possessing or distributing a plant that is objectively safer than several unscheduled substances like alcohol or tobacco. That's why our organizations have come together to form United for Decriminalizing Marijuana. You can go to decriminalizemarijuana.com. Help join us by signing a petition that we're going to send to the Biden administration, outlining the 3 asks that our colleagues laid out today, and really asking that the president does use the full weight of the presidency to take this moment and capture it so that we can fully make sure that we are getting the best impact for the communities who have been disproportionately impacted by prohibition. So please make sure you're going to decriminalizemarijuana.com, signing the petition, sharing it with everyone you know. We need to have a full-throated voice going to the administration saying this is the unified call for what we need to see in order to consider things to be as close to decriminalized as possible, right? So we're going to shift things into the Q&A portion of today's event. So my colleague Justin Streckle is going to come on and take that portion away. But please do make sure you're going to decriminalizemarijuana.com. Let's help the Biden administration achieve their goals of decriminalizing marijuana and make sure that nobody is ultimately serving time for possessing a plant.
Kico, thank you so very much for discussing our call to action. As you know, everybody who signed up for this, we encourage you to go to decriminalizemarijuana.com. We will be able to read all of the acts that we just put out, find out more information about the organizations from which our speakers today hail from. And now I'm very excited we got some great questions that have been sent in both in the Q&A feature and some that have been chatted to the hosts and panelists. So I'm just going to dive right in. If you have any, please drop them in now so we can make sure we get to them. Kapp, I'm going to come to you first because I know this is something you are an expert on. Somebody asked about the administrative review process And what are agencies even allowed to consider as part of that process, and why do you think that's allowed it to come to Schedule 3?
Yeah, thank you for the question, Justin. As federal agencies, specifically the Department of Health and Human Services and the Department of Justice, are reviewing how marijuana is scheduled under the federal level, it's important to note that agencies aren't able to look at every single factor that they want to. They are specifically limited by the language of the Controlled Substances Act and the fact that they're specifically looking at a drug for its potential medical use and also its abuse potential. Some of the things that the agencies are looking at in their consideration are scientific evidence, the history and current pattern of abuse, any evidence of dependence or liability. But I think for our purposes and what I want communities to understand is that there's this whole process that we have at the federal level, this administrative process that's happening right now, to take a comprehensive look at the harms of marijuana. But what we're ignoring through this process, and that's why I've been referring to the administrative review process, and I say this in my individual capacity, as an administrative whitewashing, because what we're not looking at in this administrative review process, we're looking only at the harms of cannabis. We're not at all looking at the harms of cannabis criminalization. And many folks can now acknowledge that criminalization of cannabis has been more harmful than cannabis itself. We are, in this administrative review process, completely ignoring the racist history that allowed marijuana to be placed in the controlled substances list in the first place. We are not going to at all in this administrative review process acknowledge that the placement of marijuana as a Schedule I substance was originally supposed to be temporary until they did a scientific evaluation, until more information came back. In fact, the Controlled Substances Act originally required a commission to study marijuana. And this commission came back and said that marijuana should be decriminalized, that personal use should not be criminalized. But Nixon wanted to be racist. That was his intention. And he said, I don't care what this commission says, we're going to place this in the most restrictive category. So we're completely ignoring the history, which I think is a failure of our federal policy. But even beyond the intention and the history, which more importantly, we are ignoring the impact, the harm, the racial impact of criminalization. We are, there's no space in the administrative review process to even acknowledge the racial disparities. Yes, President Biden has acknowledged in his rhetoric the racial disparities, but in no other sense of federal policy are we able to just rely on the president's statement. There's no process to acknowledge the harms of criminalization that has been a war on people, primarily Black and brown and low-income people. So thank you for the question, Justin.
No, thank you for that ask, Kat. I know it's wildly frustrating for us to have to see our government be shackled, as you said, an administrative whitewashing. Like they can't even take those things into consideration under the law. It is the law that they cannot do that. So thank you for that, Kat. Got another question I'm going to come to, and Chelsea, I'm going to ask you to take this one. Chelsea, what would you see as, this was asked in the Q&A, what do you say is the biggest barrier to organizing and coordinating cannabis advocacy efforts as a collective community, and barriers to building the movement?
Thank you so much for this question. I think that number one, we're probably going to be looking at many of the same barriers that come up in many different types of movements. Number one is that the cannabis advocacy movement is so much more than about the plant. We just heard Kat talk about the impact of marijuana itself versus the impact of marijuana policy. And so, as we are working together to build a collective voice of, hey, what is the actual problem with marijuana being scheduled the way it is, and what is the solution? We can see right now that there are many problems as well as several steps for a solution. And so, right now, it's going to be on us as advocates and folks that are organizing on the ground to continue to talk to folks in these spaces, to connect them with the problems that we all see, and really work to have a collective voice. That means that we're going to have to be open to who we are working with in spaces that we may normally not be. It also means that we have to now come together and start hearing stories that we've never even heard before. And I think too, it's really going to have to push us to thinking outside of just a model of cannabis advocacy. This is really advocacy for people. This is real advocacy for folks that are still pulling themselves out of a pandemic, and people are living in a scarcity mindset. And so they are facing some real difficulties just to survive. So right now we have to build the movement where people are. And I would say very openly, as part of this movement in cannabis advocacy, that we are still transitioning this movement to speak the language of the people where they are on the ground. But I'm really excited to be part of that transition and looking forward to building this movement for a win.
I want to underscore what Chelsea said about collaborating maybe with people you haven't collaborated with in the past. We weren't as thoughtful as we could be. I hope you can notice about coming up with asks that people can agree to, regardless of what you think about rescheduling, 280E, safe banking, if administrative descheduling is possible, all of these different things that we might not feel the same way about. My hope is that these are 3 things that we can come together on.
Thank you for that, Shalina. I really, just to underscore that point, we really took these 3 asks seriously. We are, over the coming weeks, going to be putting out calls to action for other organizations to join us in these asks. We look forward to your feedback, but we wanted to come to consensus now and get these out publicly and start talking about these things right now. Mike Lazewski, I'm going to come to you next. I got 2 questions that I think you'll be good at. The first one is a softball. Somebody asked, how many states have legalized marijuana?
Oh, geez, off the top of my head, that one I may not know. I believe it's 18 adult use and 37 or 38 for medical. My numbers may be somewhat off. And
Mike,
some of that's
not including the last election cycle. We're at 23 now.
We're at 23. Yeah, it's moving so quickly, you just can't keep up with it anymore.
But if I can, I do have a more sophisticated question for you, and I know you're going to hit this one out of the park. Tom Angel asked in the Q&A, in terms of what you want the president's administration to do, can anyone weigh in on whether administrative descheduling is legal or even possible? Some have called to say that calling on him he can't do it without Congress, while others have referenced international treaties and other things. So I know a couple others are going to want to jump in, but have you address that question first.
Yeah, so there's the Controlled Substances Act is very specific. There are 2 ways. One, this Controlled Substances Act has a very specific way that a substance can be either rescheduled or removed. The statute talks about removal. So you can remove substances from the CSA through the administrative review process. Congressional Act is obviously another way of doing it. You can just amend the CSA and pull marijuana and THC out of the statute. So those 2 options are both available. Now, when it comes to some of the treaty obligations and those sorts of things, that really comes down to a matter of political will. And again, the Controlled Substances Act, the provision where it talks about how the DEA is supposed to interpret what HHS transmitted to them, speaks very specifically or it uses this term, whichever schedule they feel most appropriate to meet our treaty obligations. So that leaves a lot of room there for interpretation. And if we take a look at other countries such as Canada that have already legalized marijuana, they may be doing it outside the scope of the treaty obligations, but there's no actual penalty for that. It's not like the UN has suddenly cracked down on Canada and imposed sanctions on it or sent troops to Canada. That's not going to happen. So we don't have to worry about that. It's really just a matter of political will. So the opportunity is there. Now, if we're talking about whether or not that is likely, that's probably, you know, I don't think anyone is going to come out of you know, the seminar thinking marijuana is going to be descheduled because the DEA is going to be our savior. But it is possible. It is the move they should make. But there are these other things the administration can be doing in the meantime, even while marijuana is in Schedule 1. So all these sort of things we're talking about that the administration could do to remedy the situation, those could be done today while marijuana is in Schedule 1.
I just wanted to add one quick point about that sort of political will thing, right? Like that's why we are coming together. That's why you guys should go to decriminalizemarijuana.com and sign the petition, right? Very much everything about the political system is about the external pressure we put on our elected officials, right? That's why we're coming together. We're having these asks and really trying to have a fine point as to like what we want to see from the administration. So just wanted to make one more quick plug, decriminalizemarijuana.com, sign the petition, because we need to create the political will, because it's not going to just come naturally from other places.
And just to add to what Mike said earlier about the treaty obligations, you know, there are countries who are forging ahead, notwithstanding the treaty obligations, and it's really important to remember, as a kind of matter of realpolitik, these treaties. These are U.S. work product, right? These are things that we actually force down the throats of other nations through the UN. And so, you know, if we wanted to ignore it, too bad, so sad, that's what's going to happen. So just wanted to add that as well.
Thank you so much, Khurshid. Now, I will say we've had a number of questions just get dropped on us, and we were planning on wrapping up by 3:45. So I'm going to try to get these, address these pretty quick. One person commented, but pardons don't expunge records. That is very true. And in order to create a federal program to expunge federal records, that is likely going to have to take an act of Congress. Possibly one of my colleagues would disagree, but and that is something that we have seen put into legislation, such as the Marijuana Opportunity Reinvestment and Expungement Act, which has passed the House now twice, and a few other bills that have been introduced in Congress. There is one other question that came in is why not deschedule rather than decriminalize? This is one of those questions where the language that we use, there is no federal decriminalization that is not descheduling completely. But there are ways, and this is what we were putting forward in our first ask that Shalene spoke to earlier in the call, about getting guidance memos out there so that way law enforcement isn't wasting their time and they are directed not to de-escalate the war on drugs. And then Kat, I got a last question that I think you're gonna hit out of the park. And this is an important one. There was a recent Congressional Research Services report that suggests that people or states may be able to comply with the CSA if they're using federally legal medical marijuana. Is that true? And can you tell us more?
Yeah, Justin, thank you for the question. I'm usually a big fan of Congressional Research Service reports, but when this particular report came out and I read it, I was particularly concerned. It suggested that it suggested that there may be this framework for quote unquote federally legal medical marijuana, and that if states or people just complied with the CSA and they were using federally legal medical marijuana, then they would be protected. And this Congressional Research Service report also articulated that if folks were legally using federally legal medical marijuana, then they would be protected for things like immigration consequences. And I just want to emphasize, because my concern is that the headline after this rescheduling conversation is federally legal medical marijuana. And the reality is that the only way that a state could comply with this new framework for federally legal medical marijuana is if they got rid of every single licensee that was in their current program and waited until those licensees got a DEA registration. And if they got rid of every single product that was on their market until those products went through the FDA approval process. What this means in part is that moving marijuana to Schedule 3 is not going to create immediate access for patients. You know, this is supposed to be about patients. This does not create immediate access for patients. The only people who are going to be consuming marijuana legally are those who are consuming FDA approved products. And there are not, to date, there are not any, there's a cannabis-derived FDA-approved product, but there are no cannabis drug products that are FDA-approved. So if we were to reschedule marijuana tomorrow to Schedule 3, as it's been mentioned over and over again, there would still be criminal penalties, even for folks who are just using medical marijuana, consistent with their state programs. I think it's going to be increasingly important for us as advocates, for policymakers, for Congress, regulators, for the president and his administration to understand the importance of the rhetoric and language that they're using. Because the concern is that if we say the headline is federally legal medical marijuana, and folks go and change their behavior, that could actually have some adverse consequences. So we don't want to overstate or overpromise these particular reforms, but we want to be able to continue united to push for marijuana decriminalization.
Thank you so very much for that, Kat. There is one other question that came in that I want to get to. So Natasha, somebody asked very simply, let me pull up the question. How do you believe the president can support legalization?
Well, to support legalization, the president can do things like explicitly support marijuana as a legalized substance, calling for legislation that protects public health, that protects consumers, that protects workers, and that protects parents' rights. We can prepare federal agencies to support all of those things, as well as prevent monopolies and big pharma, big tobacco, and big alcohol from monopolizing the ability to have space within the cannabis infrastructure. At the end of the day, rebranding prohibition is not a solution. We have to move forward in a way that actually allows for legalization.
Well, that is the answer that I think that we should end on. I'd like to thank again all of those who spoke today as part of this webinar, this curtain call for United for Marijuana Decriminalization. We have our work cut out for us, but with prohibition having been in existence for over 80 years, we are ready to take on this fight to its finish. So please visit decriminalizemarijuana.com. Take action on the petition that we set up, reinforcing these asks to the Biden administration. You can that'll get you on our email list. So we'll be following up in the future with more calls to action. We are going to be circulating amongst other advocacy organizations and those to bring unity around these three asks. It's our sincere hope that you'll spread the word, send folks to contact us. Information for all of our organizations are hosted at decriminalizemarijuana.com. And you can also email us at weshould@decriminalizemarijuana.com. So thank you all so very, very much. Please stay in this fight with us. We are so close to achieving something that is rational marijuana policy in America. And the president and his administration taking action on these three asks are the most logical, rational, and right next steps to take. Thanks again. Have a great rest of your Thursday.